I'm seeing all sorts of videos online lately about people shouting something, saying something, and being arrested under the Public Order Act under various offences. And it really seems to me that free speech is being stamped down on recently for what people are saying. There's a lot of peaceful protests going on, but they spill out to a few choice words here and there, and people are getting arrested for it. So I thought I'd do a very, very quick overview, because I'm about to go training, of some of the public order offences here. Now, there's a few public order offences, and the one that I've seen police in videos arresting people for, without referring into any specific case whatsoever, is the one in the middle. So we've got a Section 4, Section 4A, and Section 5. Now, I'll go briefly over those, because the one in the middle is probably not so serious that it would require a lot of proof on the police part, but also not too lenient either, so it's falling in the middle. Allow me to explain. So let's start with Section 4. Now, most people are not going to get caught up in a Section 4 unless they are really doing something bad, because persons guilty of an offence here, if they are using threatening, abusive or insulting words or behaviour, or writing signs and visible representations, etc., which are threatening, abusive or insulting, which have the intent to cause the person to believe that they're going to use immediate unlawful violence against them, or by any person to provoke immediate unlawful violence, etc. So this has the intent aspect, which is obviously more difficult to prove, and the immediate unlawful violence bit, which, unless it's like, I'm going to bash you up right now kind of words, those kind of things will make somebody of reasonable firmness to fear immediate unlawful violence, or that someone else is going to suffer immediate unlawful violence. So Section 4 is a little bit more obvious. On the other end of the spectrum, we've got Section 5, which is simply where a person uses threatening or abusive words or behaviour, or disorderly behaviour, or displays any writing, sign or other visible representation which is threatening or abusive within the hearing or sight of a person likely to be caused harassment, alarm or distress thereby. So someone just has to be in hearing or sight of what you're doing. And if what you're doing and saying is threatening, abusive words or behaviour, or disorderly behaviour, then you could be in for Section 5. Now, the one in the middle, which I see videos and I've heard rumours of the police going after, is Section 4A, which is not as serious as Section 4, not as light as Section 5, but enough to really hammer somebody if they do get caught up on a Section 4A offence, which is a person guilty of an offence if with intent, so they still have to prove the intent, to cause a person harassment, alarm or distress, if they use threatening, abusive or insulting words or behaviour, or disorderly behaviour, or displays any writing, sign or other visible representation which is threatening, abusive or insulting, thereby causing that or another person harassment, alarm or distress. So a bit like Section 5, but you've got the intent element there. Now, aside from the intent element, which they have to prove that you intended to do that for Section 4A, obviously, you don't need the intent for Section 5. It just has to be that someone is caused harassment, alarm or distress. On both of those, what we come to is the definition and the real meaning of harassment, alarm or distress, which I've got a bit of a problem with, because I think it's too vague. It's not defined, for one, and it is open quite broadly to interpretation. Now, some cases will be very obvious and some not so obvious. So what we would do as practitioners here is we would look to this for Section 4A, the definitions and then the meanings and interpretations. And so we've got here, this is a criminal practitioner text. Now, it looks at the meaning of harassment, alarm or distress. Now, as you can see here, this is what lawyers, barristers will refer to when looking at these offences. Harassment, alarm or distress have not been defined, but it's assumed that they are the ordinary words of the English language unless and until a definition is provided. And the guidance is, in various cases and so on. And so one of those cases I'm going to show you here, where we look at the meaning of these words. Now, without reading them out, because it's a bit vulgar, you can see the yellow bit highlighted at the top. This very young boy shouted abuse at the police officers and carried on after being told to be quiet. As the police left the scene in a police van, Mark, the youngster, made a gesture at the police officers in the van and shouted W's. And at that point, he got arrested, etc. Now, long story short, this was a Section 4A. So was the police officer caused harassment, alarm or distress by that gesture? Now, the court looked at it down here and looked at those words. And ultimately, said the officer didn't suggest that the behaviour had caused him to suffer emotional disturbance, and it would be most surprising, the court said, if it had caused a mature police officer to suffer emotional disturbance at that gesture and wording that he used. Although the case does not record the physical details of the parties involved, we're told that it's not in dispute that Mark was only 4'9", the police officer was over 6 foot and weighed 17 stone. And he was an experienced officer, so essentially he wouldn't have been caused any real distress. But then the court went on to look at, well, what does this mean then? The question whether he suffered distress within the meaning of Section 4A. The word distress takes its colour from its context. In part, it's a trio of words: harassment, alarm, or distress. They're expressed as alternatives, but in combination they give a sense of the mischief that it's aimed to prevent. And I think this is outdated, and we need a definition, because we need to know where these boundaries are drawn, because otherwise it is open to interpretation and you could get convicted on what you might think of as an arbitrary interpretation of what happened, what was said, under an undefined offence of a few words here. So the court said here, and this is really what we go on currently, the court said, they are relatively strong words befitting an offence which may carry imprisonment or a substantial fine. I would hold that the word distress in this context requires emotional disturbance or upset. The statute does not attempt to define the degree required. It does not have to be grave, but nor should the requirement be trivialized. There has to be something which amounts to real emotional disturbance or upset. So if you go around calling somebody an idiot and they make a complaint and the police come to arrest you for a Section 4A offence, was there any real emotional disturbance or upset because you called them an idiot or similar? There's a whole raft of different words and offences that you could shout at somebody, which could be insulting, abusive, even threatening. But would it really cause that person harassment, alarm, or distress? Harassment obviously needs to be a course of conduct, meaning on at least 2 occasions. Alarm or distress, as the court said here, it really needs to be something that requires real emotional disturbance or upset. So unless the words used and the way that they are used and what someone is saying and doing, unless they are likely to cause real emotional disturbance or upset, that it doesn't have to be too grave, as the court said, doesn't have to be causing real serious emotional breakdown of this person, but also not trivialized. If someone walked past me and said, "Ha, you idiot," because, I don't know, they recognize me and they don't like me, for example, I can't report that to the police on a Section 4A offence and say, he intended to cause me alarm and distress. Maybe he did. But if it wasn't something that would amount to real emotional disturbance, then that doesn't qualify. If they were standing there for 2 or 3 minutes, absolutely shouting, ranting, raving, pointing, swearing, even gesturing, poking a stick or whatever, even if it didn't quite meet the threshold of provoking the fear of immediate unlawful violence, if it didn't quite reach that threshold but was still in many people's view a Section 4A offence because the intent was there, maybe that would cross the line. But just calling someone an idiot and having a bit of a shout with somebody should really not cause anyone real emotional disturbance or upset. So I hope this video, not as legal advice, of course, because there's no specific case referred to here, but I hope this video does serve as some kind of guidance to the general public, the police even, and anybody else that sees to report any kind of offence and ultimately waste police time for something that really ought not to be reported to the police, really ought not to amount to an offence of this sense. And just for what it's worth, the same really ought to apply for a Section 5, although that's just dropping the intent element. It is just where a person uses threatening, abusive words or behaviour or disorderly behaviour or displays any writing signs, etc., within the hearing or sight of someone that's likely to be caused harassment, alarm or distress thereby. It just drops the intent requirement. But you still have this hurdle that there needs to be a real emotional disturbance or upset. So I hope this provides some clarity, and if it does, please do subscribe to the channel, share it with somebody so we all know where we stand, because at the moment the policing seems to be getting a little bit out of control. So for that, please do like the video and subscribe, and I'll see you in the next one.